Yes.
Yes, Savan.
Good afternoon, sir. So my question was that since we can see that the tides of globalization are increasing day by day, so it may be can you see a possibility that the sentiments of subnationalism will be diluted because this protection which has been given are to somehow protect the subnational sentiments of the particular region or to protect even. So will that subnationalism be diluted in as the globalization will grow? Thank you, sir.
I think at some extent already it happened, like, in Sikkim, if you see, it's not like, Arunachal, Meghalaya, Nagaland. Now Sikkim has a lot of, it's one of the chosen decision, like, destination for the pharmaceutical companies. A lot of pharmaceutical companies have shifted their educational institute also going to the Sikkim. That has some way, so it has both sides. People see it generates, like the government says, more pharmaceutical companies come there, so that will generate job or employment, economic growth of the state, infrastructure, a lot of things they link and they support. But the fear, what you have expressed, like, we tend to ignore, and some way we tend to ignore overall. Even quote is like, it's a globalization is unstoppable. That is like, if I have to warn, because this has become a global phenomena, and it's not only rich nation, even poor nations, and so a lot of changes will take place, and after some time, completely your own identity will merge. It's like, the city structure with the more communication. What Gandhi used to write, sir, Gandhi is like, Hind Swaraj. So Gandhi was never in favor of, like, rapid industrialization. He never wanted people to move from one city to another city. So he focused more on the, like everybody criticized that particular time and even today, like, if you, uh, it's a village economy, or we don't need to go for the rapid industrialization and other thing. So what he thought about, how this will, so village is like, everything will change gradually, and that has happened. And same thing will happen. I said also in the beginning of the talk that globalization, cosmopolitanism, this thing changes. Now they are also conscious about the education. Earlier they lived like, boy, girl, they have lived on their own society, they never moved. But now they are moving out. If any city, if you go West Bengal, Calcutta, even in the Darjeeling, number of places they are studying. So things are changing. So education, new generation is very much like, advanced, and particularly tribal people, uh, much better if you compare to the new generation. They are good in the music also. They love North Korean, like, songs, and then the TV channels are popular. So they are very advanced in number of aspects in new generation, and they have equally good Hindi or English. अभी कुछ दिन पहले ही what I think some of you might have seen one Nagaland minister. He came on the television, and what he said, कि when I say somebody कहीं पे मैं गया हिंदी में he was like talking in a very good Hindi. मैं गया और मैं बोला कि मैं नागालैंड से हूँ, तो लोग समझे कि स्वीडन और फिनलैंड के बगैर में नागालैंड है। तो बोल रहे कि कहाँ है नागालैंड, बोले कि भारत में भी। तो मैं बोला कि मेरी आंखें बहुत छोटी छोटी, तो मैं ऐसे भी सो जाता हूँ, तो पर लोग को लगता है कि मैं सो भी जाता, तो लोग को लगता है इसकी आंखें छोटी है, तो कोई उसे माइंड नहीं करता। तो ही इज वेरी जोवियल ऑल्सो। तो वही बता रहा था कि नागालैंड में हमारी इतनी ये है कि मैं जाता हूँ तो लोग समझते हैं कि स्वीडन है, और देखने में मैं ऐसा ही थोड़ा सा समझते हैं स्वीडन और फिनलैंड के आसपास। तो अभी भी हम उतना माने वो टच में नहीं है, अभी भी अरुणाचल प्रदेश, नागालैंड अगर थोड़ा सा, लेकिन स्लो है डेफिनेटली, बट these are the challenges are there.
Sir, I have a small question. Sir, Henry Main has said that Indian society was duty conscious society, and with the coming of British people, they now are aware about right consciousness, and it is because of right consciousness litigation started in formal sense. And similar kind of dialectics happens in modern society also, whereas state legal system and non-state legal system imitates each other. For example, tribal peoples try to imitate official system, coercion, adjudicatory mechanism, etc. And similarly, a state legal system also try to imitate many of the features of tribal system, conciliation, mediation, all these things. But original aspect has lost. So there is a hybrid kind of giving and taking from a state legal system and non-state legal system. But ultimately, the characteristic of mediation in non-formal sense has lost. Nyaya Panchayat is classic example that it appears to be Panchayat in classical sense, but it is not, as Bakshi wrote and Mark Calendar wrote. So don't you think, sir, we need to reinvent official legal system as per the parameter of indigenous cultures, indigenous values, because unless and until we reinvent our official legal system, it can't be effective.
And in that direction,
Am I allowed to ask?
Yes, sir.
So I will add to what you say. Whenever we note it here, we are all talking of globalization, cosmopolitan culture, etc. I think over the last few years, we are also seeing a movement back to localization. For example, cooperative group housing society is a very big phenomenon in Delhi. So we don't want to go to government kind of sponsored courts and tribunals. Of course, there is a complete setup, but the cooperative societies themselves have been given sufficient rights to manage their affairs and even to control the conduct of the members and punish them. Similarly, disciplinary proceedings in various government bodies, colleges, universities. So there is an attempt to kind of localize things again because my understanding is that the government machinery is unable to take the load. And of course, the issues that you already mentioned in reference to matters. I mean, I, for example, don't want to go to a Thana with my with a complaint. I don't want to go to 30,000 for adjudication of my dispute. So, do you think it is possible that even within the state-controlled or guided system, it is possible to revive this little bit of localization in a bigger way?
I don't know how far I can answer, but still I'll make an attempt. Taking both questions together. Within a hierarchical order, if you see that exists, what you have said, informal way, and also the cooperative society example you have given, even in the college, internal complaint committee, and even for a number of things like the university system has also complaint grievances. It's not you have to go to the court, and they also send you back if if matter is related. It means court also says, keep us, you have to exhaust administrative measures, whatever is there. So there is a already well laid down procedure is there. It's not court comes first. Court only look into when they say procedure has not been followed. Or the entire exercise court, if I understand, they look into the whether procedure which has been laid down, the trust. If procedure has been followed, then they look into the other aspects, whether decision or views or whatever recommendation has been made that is based on a regional region grounds. And some way we tend to miss like human rights issues. So we always look into you are looking into the Supreme Court judgment. We tend to miss the judgment rendered by the NGT, National Green Tribunal. We tend to miss the decision given by the National Human Rights Commission of India. So if a person, suppose he approaches you and he go I'm not taking in the tribal context, but a person he approaches me and he says ki I have been denied, or I went to the police station, police has refused to register an FIR, and this happened, and such a senior police officer is also behind. So I will advise him, you don't need to go anywhere. You write simple a letter. If so according to the rules of NHRC, the first public official must be public official. Complaints should not be more than 1 year old. And then if you write a letter, simply writing a letter. No, even in an email also, you can send the email. You don't need to write also in a registered post. Even in email, a case will be registered. and entire communication is done through the written communication. Entire procedure is followed. In rare cases, they ask victim or police officers to come, but that happens in very rare cases. But commission has granted compensation. Though it has a civil court power, it's not the criminal court power, but it has granted compensation. It has recommended suspension of the police officer. So in a mode of the redressal system which is available in the NHRC system is inexpensive, quite fast. I'll not say very fast like in the way, but a court decision can be interim decision can be immediately. A final decision takes generally 2 years. So a lot of the changes are there where government is also, and then 73rd, 74th constitutional amendment. Then even the Gram Nyaya, these are the focus of the localizing. But some way, the point which we have to locate, Gram Nyaya is not functional. Number of states have now started. Madhya Pradesh has started. Some of the states Madhya Pradesh have, but they are lack of fund. There is no sufficient fund. If you you have act and you have created a system, there is an infrastructure issue is there. Every day we hear the Chief Justice and Law Minister in the same they talk about the delay in justice. We talk about the overcrowding in the prison. I gave an example. I don't know. I think there is a case in in one case I just discussing. I said these issues are continuous. It available in the overcrowding was in 60, overcrowding was in 70, overcrowding was 80. Delay in justice was always there in India. It's not. And classic example when the Bhopal tragedy gas happened, Bhopal gas tragedy happened. What government of India has done? Government of India has what is the right forum? So first they went to the United States of America, and I suggest all of you to read the comment of Justice Kennan. What he said. So one hand, government is saying, we don't have sufficient taught lawyers. One. Second, our it's a very complex issues. So court, it's country itself is arguing before the court, district court, and saying we don't have capacity. We are unable to handle this case. However, if you cannot no, he said, it's a forum non-convenience. It's not the right forum. Your forum is there. And then he praised Indian judicial system. He said, you have very good judicial system. And I believe why you are come again. Otherwise, if we start taking, it will again reset the tone of the colonialism. We are doing. So you are independent, you go back. And there also, delay also is issue, 1986. अभी भी Supreme Court का होगा और High Court. But what we see, even in Himachal Pradesh or in Delhi or nearby Delhi, if you just move to 50 kilometers, infrastructure is virtually collapsing in the district court. How a young boy and girls sit, many young boys, after working for some, so initially they think, judiciary is very good. So you get a power, somebody to salute you, open your door, and then you go inside the courtroom. But courtroom is so clumsy, and sometimes there's no power in the remote places, small district. They start to migrate in other professions. So lack of infrastructure, so those support is required, even if you make an act. So existing implementation of the existing law, which strengthen and focus more on the local system, needs to be supported by the state. And some way, the state is withdrawing. The state is withdrawing in all its area, and that is the problem. So I think we'll leave, and the remaining 1 hour we can. जो सबसे जो सेकंड टॉपिक very important है कि रिसर्च methodology with respect to ancient and medieval India. जो रिसर्च methodology को क्या अब पहले तो methodology पर we discuss, and why should we study the law in ancient time or medieval time and modern time. What we have been learning and we have been, even the university system has like, even we hardly go back to the 1935 Government of India Act, which has heavily influenced the our own constitution. Number of provisions are same, sections like, there. But our focus, we start with the constitution. So constitution, drafting of constitutional history can be also an interesting, starting from much earlier, like, but 1935 can be, so constitutional history, if I say history, so constitution, whether there was constitution, whether like, Chanakya or Arthashastra is some way we treat like, guidelines or for the many aspects. There are a number of issues are there, but focus of the university and in the legal context or law university context or law colleges context, we see we work on the contemporary topic. अभी जैसे आज के समय में जितने भी रिसर्च होंगे, that will largely on the right to health, somewhere cyber law, right to health, IPR, and sometime in climate change. Now environment is moving from the environment to climate change and human rights. So these are the topics which students like. While choosing a topic, we have why we do the research. So it's like, of course, you have interest in the education, and that is the reason you are there. But most important factor for all of us, some way it is related with the our job prospect also. Is the topic. The second important part, the area which you work will be taken seriously by the or helpful for you in delivering lecture and classes when you take the seminar. The third point, which also institutions are looking for. If you say, I have done the research in ancient India or done Shastra, as I said, so they will say कि हमारे यहाँ तो पढ़ाई नहीं होती, आप भारतीय का संविधान के बारे में बताओ, कुछ जानते हो, हम तो नहीं है, तो it's very good you have done the research. So somewhere these are the things are there. But PhD is not the only research. So we all conduct research throughout our life. What sir has also contributed a book on Dharmashastra that might have not been not related with his PhD work, as far as I understand. So he has an interest. He has been sir has been working on that, and then he has written something like that on that particular area. So your interest, now we have to find out. So you have to balance both it while undertaking a research. Why we should take ancient research? So, and when we should undertake research related with the ancient time, medieval time, and modern time, and how it's going to be beneficial for the society, how it's going to be beneficial for you as a scholar, emerging as a scholar. These are the important things there we have to look. So if I take, say the example which I discussed in the morning also, as a scholar, I started with doing the same thing what I have just said. I did not say I looked into going back to there, and even I could have not done. There are a lot of, it's very difficult. First, like, finding materials, which very few libraries you will find. And even if you look into, you have to look into not the legal, you have to look into the other discipline also in the legal research, and then you have to just lot of time to write an article or anything in there. But so I chose a topic on the more contemporary topic when for the PhD program. But later on, my also personal association or liking for the doing research in the ancient context, it started with by chance. By chance, like, so I met one editor in a journal that is very good journal, International Committee of the Red, ICRC journal, International Review of the Red Cross, IRRC, International Review of the Red Cross, and they wanted to bring out a issue only on the religious perspective related to the laws of warfare. So Christianity, Islam, and other religions, they wanted to explore, and then accidentally they met me also. They said, you'll be interested to writing something on the Hinduism and IHL or something. I said, and then time was very limited. But I said, okay, let me try. So challenge. So I accepted that, and then I started writing. And somewhere 12 to 13 pages I did. So that is the paper. If you go search, the moment you type in the Hinduism and international humanitarian law, it will be the first to appear. The first Google search may Hinduism and international humanitarian law. Without fail, it will come first paper in the there, and that gives me my name and everything. So I wrote many papers. I wrote many papers, but this paper I feel is some way in the list. Many a large number of people have, and subsequently later on, number of scholars have written on the this subject, laws of warfare is there. So while writing, while writing this particular thing, so what you have learned, what I have learned, and what we all have learned, when you have been taught in the classroom that laws of war, the father of international humanitarian law is Henry Dunant, है ना? तो आपको लगा कि Henry Dunant is the father of international law and what he has witnessed in the Battle of Sulphur, and then he thought about he did not enter into the debate about the legality or illegality of war. He focused more on the protection and care. So entire international humanitarian law, it focuses on the protection and care of those who are injured in the battlefield. He did not go, he thought, if I start talking about the legality or illegality of war, people may not be interested. So I have to prepare people to take care of those who are nobody there in the field. So protection and care is important. If soldiers are wounded, how they have to treat it. And that is how he established, like along with the 4 5 friends, international committee of the Red Cross, ICRC. So ICRC has this journal also. So ICRC has become a main body in the international humanitarian law in that particular thing. अब हमें तो पता है कि महाभारत में, रामायण में, और जो हमने छोटे बच्चे में देखा कि किस तरीके से कि शाम के समय में अंधेरा हो जाए तो युद्ध नहीं होना है. If Kern को जब Arjun was refused to charge him, attack him when he was trying to pull his wheel. So Arjun was not keen. So that has considered that is not lawful. Something that is not morally or ethically correct. So Krishna had justified in a different way, but lawfully it is not correct. So if so a person who has injured or a person who is not in a position to carry effective war, or he has put down his arms for any reason, he should not be, even today, and even that time it was not there. So we see that particular, so when war will begin, so early morning it starts and then by end it's over. And then evening, wounded soldiers has to be taken care. So we see that all these things are available there. All these things are available in our civilization, which very much. So what Britishers have done, what Westerners have done, we have also our obligation, at least enlightening people. There is a strong civilization which exists. So ancient research in the law, ancient research in the history also. So law history is there. So we have history, ancient history, we have medieval history, we have modern history. So we stop there ki it's a history, it's a historical fact, history covers. So as sir, we were discussing with sir, before the lunch. So I said, history covers social situation, economic situation, political situation, but some way the historians have not addressed what kind of legal system existed in the ancient India, modern India. They discuss about the detail, even economic aspect, market system, republic, lot of things are discussed by the historians, which is very helpful in our writing in a book or something. But legal, we have to go back to the original text which has been left. So historians made an attempt to understand. So as a role of the historical, the focus, ancient literature or ancient, medieval literature, modern we covered, that is needed. Time of hour is there. And I'm just saying the second important point, what we have noticed, what we have observed, it's not next class, Anand will come. He's from the Rajiv Gandhi. So Madam, Sir, Rajiv Gandhi National Law School. So Rajiv Gandhi National Law School also, 1 or 2 colleagues, they work in the international humanitarian law. They have a center also. So one day, a non-governmental organization or a public spirited individual, they published, without knowing its importance, they published in Sikhism, the concept of protection or care exists. Even in time of war, so in a time of war, protection and care means it applies to all. So even if you're enemy, next moment you become friend, you have to take care of the injured. And in that context, they say, so that gentleman has not written in the context where he said कि history में the role of the भाई कन्हैया लाल. तो आप देखना कभी मिले कन्हैया लाल. So like they said कन्हैया लाल, his main task was during the war to give water to the soldiers, those who are injured in the battle. So he used to carry and while giving water, he gave water to the also to the enemy person. So he started distributing water to the, and then complaint was brought before the Guru, I think Guru Gobind Singh, and then said, there's what Kanhaiya Lal is doing, it's not correct. He's serving water and he's also administering medicines to the injured soldiers and everything. And so this so protection and care, it has forget about the Hinduism. It existed in the medieval period in the Sikhism there. But Sikhism, it has not been highlighted. It has not been done. So after a long time, this university has because in the Punjab and they feel like they have interest. I participated and they then they have called. They had a meeting in Delhi where ICRC research. So like you see the research. So the idea which was shared there, Khalsa College in Delhi University and that representative from the Bangla Sahib Gurdwara and National Law School is representative. I was also invited one partner. And then ICRC. They said, Sikhism, the international humanitarian law has not evolved from the Henry Dunant, and we have proven, so you should support us. We want to do research. So this research has not come from. So they, individual who just goes to Gurdwara every day and he somewhere by chance he started leaflet or something, and then university has noticed and then it has brought. So research has started from the a layman from outside of the campus, and that generated interest in the entire community and even the religious places, and they said okay, we must support, encourage the research and a committee. So now they have written a couple of papers on the Sikhism and international humanitarian law, the development of Sikhism. So that is the contribution we can figure out on taking any topic, because there is a gap. So research is objective of research is the filling the gap. Same time I suggest and I caution, it's not necessary if you teach ancient Indian history, then definitely you can do the research. But topic has to be what is going to be selling point for you. Sometimes teacher will say कि आप क्यों कर लिए, कहाँ कोई paper भी नहीं है. Although government, even the national education policy, they focus, universities are Indic study, they are focusing. So recent time development is there. But how much the opportunity will come, we don't know. So I personally feel that you stay with the whatever you feel comfortable in them, and chances of getting employment and any other seminar conference, because system function more on the contemporary areas of the research. But these areas, whenever you have time and throughout your academic journey, you can consider working into the academic research in the ancient, medieval, and modern. Of course, we are doing. Let's go back to the methodology. What methodology you will follow? When research methodology we talk about, we understand and we have. So methodology is it's already the incident happened. Something ex post facto research. You are not going to what is happening. Already happened, already said, already discussed. It's not new. So there is no scope of testing hypothesis or something. So you are going back to find out how society was regulated in the ancient time, how society was regulated there, how family disputes were handled, why Britishers did not interfere in the personal matters of the all communities in Indian time, why personal matters, how much personal law has been still continuing with what we have learned from the ancient time till date. So personal law is largely is there. So these are the questions. So things have already happened. So the research which it takes you in an area which has happened. It's not going to happen. That can be a chronology. You can draw key. We have moved from the ancient, we have reformed, but basis more or less if justice used to be, what are the duties of the king? These are the things. What are the Buddhism, Jainism? Many people, when we talk about the religious aspect, non-violence aspect, you go to the Buddhism, you go to the Jainism, you go to the Ashoka Dhammas. Ashoka Dhammas can be used in the legal interpretation. In the legal interpretation, or many times court uses these documents is strengthening on that particular point. So when you look into the research, so research is quite clear key document which you have to search. Search with a library based. So it's come much closer to the doctrinal method of research. The doctrinal method of research. It's not empirical research, how people perceive, but empirical can be where you go, okay, do you believe, do you see, do you support this one empirical, the response of people about something for a particular law which a community is following, you say whether this should be, so then feedback can be generated. Family law, should we shift? Should we change our Hindu family law or something like that? There is a possibility of their empirical research can also in the acceptance or non-acceptance. When you have a question, is there. But largely the ancient research methodology which will be applicable and which applies in the ancient area. So what I have done, I have 10 or 12 pages I have written, but I have written on the basis of the library. I did not go to I try to find out who has written on this particular topic. It was very hard. And of course, as sir has said, and with this, lot of Sanskrit words are there. If you go back to there, you don't need to worry about the Sanskrit because translation is there. If you have, so you should not stop on that particular count. You should not stop on that particular count because you get lot of translated work on the Ramayana, Mahabharata, even all the text you have, you can use it. The idea is go beyond the classroom, go beyond the territory. Go beyond the territory means what you write. Everybody should have a gender. So there's an interest in this particular area. There's an interest in a particular area about the error. Let's complete the methodology. When we talk about a methodology which is applicable to this system, we have found it's most suited is the doctrinal method of research. And if we focus on the types of research methodology, we find there are 3 types of research methodology is there. One is the doctrinal, second is the non-doctrinal, and third is the mixed method of research. The mixed method of research or non-doctrinal you can also call an empirical research. We all have to keep in the mind, we cannot do the research like sir. Because law research should sometimes people come and they say, we have to go for the more interdisciplinary research. But a law student, a lawyer, what lawyer has to do? Lawyer cannot write in a brief before the court. The socio-economic regions are the reason for violence against women. The large number of the accused belonging to the socio-economic. Thus, I request Honorable Court not to punish directly the government of India for the improvement of education or the economic condition. Court will say, this is not my come. Of course, I agree with you. This is the policy matter which government will do. This is the work of the sociologist. This is the work of historian who focuses. So a lawyer has to bring the law. By this act, he has violated POCSO Act. He has violated the other sections of the IPC, and accordingly he has to be punished. So his conduct has not lawful, is wrongly committed crime. So we have to focus. So lawyer कभी-कभी हमारे में ये बातें आती है और we get confused कि इंटरडिसिप्लिनरी की काफी चर्चा होती है कि आप इंटरडिसिप्लिनरी रिसर्च करें. आपको लॉ में खाली एक तरीके लॉ को डोंट सी लॉ इन आइसोलेशन. Law has to look into the action. Of course, law we have to offer a solution to a particular problem. So your study should be on the based on the problem solving, some kind of solution you have to offer. You have to also look into the effectiveness of the law. आप कोई भी legislation लगता है, you test that effectiveness. You move from what law is, you move from the what law ought to be. आप उसको एनालाइज करते हैं और सब चीज करने के तो लॉ स्टूडेंट्स को इस बात की हमेशा ध्यान में रखना चाहिए एंड वी शुड फॉलो दैट कि लॉ शुड नॉट बी लेफ्ट. Law should dominate your interpretation of the at least C part of your research. So हम कितना भी करें, that is the reason we remain law legal research is called as a library based research. हम अभी भी आज के दिन में तो हम क्या करते हैं, we analyze, we look into the law, we look into the cases, we look into the theories, and then we give our own interpretation. If we simply state everything, so doctrinal danger of doctrinal research is there, we tend to make a descriptive. So descriptive nahi karna hai. So what you have, so even if you look into the ancient, if you simply bring the facts which has been known in a different, and you cull out from the different places and you put in a book or form there, but it has to be some kind of analysis where you prove or disprove, not hypothesis, but say ki what has been said today, what has been you are practicing that exists in the ancient Indian time, the research methodology part. So legal research will continue to dominate or continue to operate in the legal area. Analysis of acts, analysis of legislation, analysis of cases, analysis of theories, and of course, when you come to the other regions, you go for the interdisciplinary approach or empirical research, how law is effective or not, and that you have to look into that. So that idea you have to keep in mind, and that is the reason whether even if you do ancient Indian history, you have to also, because many times we notice for our own students, they have written the title, but title is like, by looking into the title, it gives an impression. It can also be in a work of the political scientist. A political scientist has worked on the title. So law has to be reflected in all places, at least the first, second, third places. Law has to be reflected. So you कभी भी हम इस बात से compromise नहीं करें, or that emphasis should be given on that particular part in there. So when you do, so come back to the methodology, it will be doctrinal method research, which we are going to do under this particular thing. When you do the doctrinal method research, the first part you look into the how to analytical approach has to be followed. So analytical approach is always good. So you offer something. You offer some comments in there. You try to see whether some principles have been developed, how it has shaped the issues addressed, or how it has addressed the issue on that particular time, and whether it is relevant. So some kind of analysis is required. So analytical research in this. So if you nahi karte, so doctrinal research becomes descriptive research. Descriptive article can be useful. A textbook can be useful where you have all the content, you elaborate on that particular point, and that students feels very happy that ये चीजों को इस तरीके से point करें. लेकिन जब आप research करते हैं तो you have to analyze or critically analyze, और critics कोई कहते हैं ज्यादा नहीं करना कि theory ही ज्यादा दे दे, but you analyze and then you critique the whatever area you choose to do that. So that approach will be applicable in there is. So in doctrinal research, analytical aspect is there. Second is the comparative practice. There is a the second point will come comparative later. Historical part is equally important when we do the research. Historical research in the doctrinal research. If we are doing if we are doing history, automatically it's completely historical, but there also analytical and comparative perspective will come. How Greek civilization has developed, how the Chinese Confucius time, how Chinese system has also addressed this particular issue. So there is a perspective in the doctoral research. So you examine, since you are doing this historical research, that become not so much relevant. But when you do the research, doctrinal research for any other aspect, you can apply the historical approach. What I mean, evaluation of that particular concept, how it has evaluated over the years. So even the historical approach there is relevant. When I'm doing in the history, so I'm only digging in the history or historical matter, so that's not a problem. But when you are doing in this particular part, then you have to look into the see that comparative perspective also is there. So three broad areas which I have said in the historical, no, doctrinal research. Doctrinal research is the analytical, historical, and comparative. Comparative, three aspects you have. So doctrinal research can become an interesting. So like, and sometimes also, even if you're doing intellectual property right, your theoretical aspect is equally important. So somebody talks about the right to life, but theory, if you use justice or anything, theoretical interpretation or theoretical aspect is also makes your study little bit different. If you describe in a limited way how you organize your thought, how you go about all these things, that's up to you. If I sum up what I have said so far, uh, as a researcher, has to follow these steps. The first, that applies in both cases, in the cases of the historical research and in the cases of the general research also. Assembling all relevant facts. Identifying the legal issues. And if you are doing doctrinal research for the historical perspective, you can identifying the legal development, how it has evolved, how it has developed, how response of the society, that can also be there. We discussed the analyzing the issues with a view to searching for the law. With a view to searching for the law. When you do this research, legal research, so आपको पहले लगता है मुझे भी if I give you an example, it's not an easy. मनुस्मृति आप पढ़ लो, चाहे इसके बाद शास्त्र पढ़ लो, मीमांसा पढ़ लो, आदर पढ़, तो उसमें तो मिल जाएगा डायरेक्टली. But to make it so like then you are confined to the only Arthashastra. You confined to the Manusmriti. You are confined. So a special legal text you looked into the on that particular part. But when you are interpreting, just like Hinduism and international humanitarian law, or role of king in promotion and protection of human rights. अब आपको उसमें you have to search all the text. You can't confine only to the what are the duty of the. So if I say role of the king in the ancient time, or one point I have taken, what we had also discussed in the morning, whether rule of law existed in the ancient time or not. So this is an idea, this is the question, or this is the fact you are trying to find out. So sometimes you see, जो हम सुने, और मे भी सर थोड़ा उसमें ऐड करेंगे, कि हमें पता लगा कि राजा का भी एक दायित्व होता था प्रजा के प्रति. राजा को, so people have complete faith on the king. King will take all the king has been treated. तो अभी तक तो नेपाल में जैसे किंगडम था, तो king always worshipped as a god. He is he has been the representative of God, and he has been chosen to take care of all of us. So somewhere there is an understanding. It's not a king is only here to commit atrocities. So if king commits an atrocity, means he violates the prescribed norms, prescribed practices which they believe. So somewhere it has king. So in ancient duties की बात क्या करते हैं, तो ancient India king had a duty towards his citizens. for their betterment, for their welfare. So king had a duty towards his citizens in the ancient time, or Hindu civilization, particularly, even the other civilization, I'll not say only, in all religions with some way, there are some points which are very important. So how you will learn this factor? So if historical research cannot be done only on this, so you can do what is the view of Manu on the laws of war, judicial system was there, that the legal text only confined, then it's become only. But when you have taken a broad topic, the punishment in ancient time, what the role of the king, which you try to interpret, then you have to read historical book. So many things like, even in this book, article, I'm just giving you an example. Uh, I cited A.L. Basam, The Wonder That Was India. So it's a history ki kitab hai. So then even Romila Thapar I cited. So I cited A.L. Basam, The Wonder Was India, New World, and then Percival Spear ki history ki book. So history book became just to search it on the laws of warfare. So I looked into the other books. So I have not looked only on the Dharma Shastra as another, but I have tried to see on that particular point, and then I just then, of course, there's 8 volume that is very P.N. Kane's book, Pandurang Burman Kane, P.K. Kane books, History of Dharma Shastra, 8 volumes, उसमें आपको पूरा चीज मिलता है. That is the best book you have there. I'm just looking for this. So the one line it says, Hinduism, like most religions, believes that war is undesirable because it involves the killing of fellow human beings and hence should be avoided as means of settling disputes. अब ये मैंने कहाँ से लिया? It's not my original. So this is I have borrowed. So I read the book and then I searched. So I found, the other text also is available, but closely I have looked into the Basam book. It's mentioned there. So other texts also. This is not the Basam. Basam is also used from other sources. So this particular, Hinduism, they are avoiding war. They feel, war should be last resort. Even if you look into the Ramayana, that's Lord Rama tried. विभीषण को बात के बात करके Mahabharata also effort was there to settle down peacefully. The war was not the first. War was not the first attempt. War was the last resort when everything has exhausted. Means Hindu's philosophy, it speaks about pacific settlement of disputes. So one can argue when you go in the classes, you can argue, and you can also not Hinduism, even in the Buddhism, Jainism, non-violence and other things can be a part of your research. So when we look into, so I'm saying, so when you look into the ancient Indian, so reliance on the history book becomes very important. Reliance on the historical book become very important for their in general description of any subject. So you have to go into the library, you have to research the Dharma Shastra, and that is the major challenge because books are not available, books are not easily available. So you have issues in your mind, you start looking, and then you find it's very difficult to write. The second example which I give, we talk Vasudev Kutumbakam. So Vasudev Kutumbakam सबका world is one और सब आए के रह सकते कर सकते. तो कभी-कभी when we talk about, so one can write you can also put the historical facts in your contemporary writing. Historical facts in the contemporary writing. It's not necessary that you have to write a detailed article on the ancient, but ancient ideas can be incorporated in your regular writing on the contemporary. If you're writing on the environment law, you can always describe about the concept of the preservation or protection of environment existed in India time immemorial, and it has been in various religions. 1 page, 2 page, 3 page, you can do that. Human rights की बात करते थे, you can always go and say Hinduism human rights is always propagated in Hindu, various literature, even Hinduism, Islam also, even the Christianity, and then you can say, you don't need to so this becomes a perspective in your research. When you talk about the ancient perspective, so it comes perspective in your research in a limited manner. You are not doing, you are talking about the modern development of human rights, but you started with the development of human rights from the ancient India and shared some of the text. In one pages or two pages, you can put lot of information related, which can also helpful for the researcher is there. So that approach can be also there. So when you write historical, I said ki doctrinal research, historical research is equally important. So what we are doing historical research, when you are writing a research into your contemporary topic, some can look into, we have looked into, someone can look into the whether IPR idea, what the author concept was there. कि समाज में जो पुराने जो किताबें लिखे और उसके समय में क्या कोई प्रोटेक्शन था, कोई राज की तरफ से, किंग की तरफ से कुछ सोल्यूशन की कॉपी, बहुत सारी चीजें we got in environment, we got in the laws of warfare, we got in the other aspect. But if you start thinking about fully and say, I try to find out whether some kind of protection to the creator, but the innovator and authors were existed in the ancient India or not. We have not looked into that. Maybe there. So somebody, if writes, that becomes a very interesting. He or she can look into that particular aspect, whether there is just some kind of ancient time uh, concept of intellectual property rights existed or not existed. Let's come back to the what I said, ki Vasudev Kutumbakam. So the Vasudev mean you believe in the universalism. You believe. So as a Hindu philosophy, we believe in the universalism. So we never talked about and thought about the concept of nation state is supreme. We said, we all have a right to exist peacefully. We love neighbors and everybody can come and move. So when you write something on the refugee law, when you start writing a refugee law, so what you will start? You will start in 1951 Convention on the UN Convention on the Status of Refugees. So you start, it defines the refugees. So on that, who has a protection? The states which were party of the 1951 Convention, not the rest of the states. So only the states which are parties have an obligation. But when you adhere to the Vasudhaiv Kutumbakam principles in your writing, he said ki whether India is party or not party, we have a culture. We have a culture, and I think you might have seen also in Jamnagar, Maharaja Jamnagar, in the second during the when Hitler was in rise. So lot of 200 families with children, they moved. Somehow they managed to come out, and they see they were like 300 to 400 people. They moved to number of countries. No country has given them shelter. So finally they got shelter in this. So there was no refugee convention or law. So he said, we must, the Raja of Jamnagar, he welcomed the family, treated them nicely, and they still some of the family members, they come back. And there is a historical fact. So a person, a king, he said, the person who is being persecuted must be treated humanly. So human rights ka preserve, a person who is being persecuted must be treated humanly. So number of states said, it may antagonize Hitler, or it's not right or something, but he did not bother. And you see that one of them from that particular group, the children who subsequently became the president of the prime minister, president of the Poland. So that is also in the TV, or you see Jamnagar. So even the Arabs, when they came into India, so Arabs, when they came to the India, and so they wanted to settle and do their business here. So through the Gujarat, I think Gujarat port somewhere they landed, and they met the local king. Local king said, "Ha, you are okay, you come here." So there's no passport, visa. They said, "You come and settle, and you are fine, no problem for us." Till so what is there? So you are also so a glass of milk. You are also sugar, oil, meat, and mix it. So you taste it so that you will be absorbed. And so you live like this. There's no problem. And this is how we admitted people in the history. We admitted people in our territory. We accepted the people movement starting from ancient to medieval, and then also so Mughal came and they adopted the country. They become part of the. Except the Britishers have not. But you see that this Indian civilization, so assimilation local integration, these are the concept, assimilation, local integration in the Indian society. When we talk about the one of the permanent durable solution, one of the permanent solution in the refugee law is the local integration. So local integration existed. So just few line if you write in your thesis or your understanding, and that makes your presentation also different. That makes your presentation also unique and different when you try to bring something on that particular. So that is the reason I think there is a always scope. There is a always scope to bring something from the historical facts, from the other historical and medieval. Historically, ancient time, there are a lot of literature are existing, or ideas, concepts, principles or doctrine which existed in the ancient time needs to be incorporated, highlighted. What has been done? It has been done by the always Europeans had a monopoly. Some way the books which has been written is largely by the Europeans had an opportunity, and there which I shared with the sir a few minutes back we discussed about that. And so how your civilization was critically observed by the Britishers, critically observed by the Britishers and others. And that is the what I discussed in the morning. And I noted this one. So international law. So sources of international law. There is a book which I said, and there in the introduction I read, where it has been found. So when you go into the class of the public international law, you will be informed who is the father of international law. So you say, teacher will say, ki Hugo Grotius is father of international. If you ask, had you asked same question, no longer he is there, Professor R.P. Anand. He said, no, the sources of international law or father of international law is India. India had duped it. We traded almost all parts. What Indonesia, Malaysia, Far East countries, that was total under the Chola, Chera, Pandya empires. They expanded there. We went to the all parts of the world. We had expanded. We had a trade with that. So a lot of concept like Duta, Duta existed in the diplomats. Diplomats should not be killed, existed in the ancient India. Maybe so Hanuman has been sent as a tool to the Ravana. So you see that, and those should not be attacked. Those should not be killed. So these principles which have been codified subsequently existed in the ancient system. But how the system, some has positively responded and some has negatively responded. And there somebody has which considered as an authority on the Indian ancient history, Henry Mann. Henry Mann, he described the legal system of ancient India as an apparatus of cruel absurdities. So so he interpreted it his own way. He said, "Ye kya hai? Ye to bakwas hai pura, cruel absurdities." He writes. He says that particular system. Wow, here I am coming. I'm saying there are a lot of good things about the ancient. So he, and he not only he, others also had a similar opinion and said that this last time, he said in Indian people, I'm just taking out. He said Indian people had always associated government with arbitrary and uncontrolled authority. So they came, they looked into our text and they interpreted in their own way. They interpreted in their own way, and that is the reason we rely. We have even Percival Spear. We read A.L. Basam. Of course, A.L. Basam book we like it very much, but they have dedicated. But somewhere some kind of element of bias is there. With Indian authors also, even the Western authors. So there's a plenty of scope There's nothing much you have to do. There's nothing much you have to do. You have to only dirty your hands. In the library, instead, these books are lying there, desperately looking for someone to take it out from the shelf, clean it properly, and then start reading. So these books are there in some of the library where historical approach and medieval approach there and there. So like, and then it's a some kind of mixed study, I'll say mixed approach, where you have to read history books, you have to read up everything, or like, other legal texts along with the history book. Then your ancient research, like, work will be there. So there's a plenty of scope is there in working in the ancient time, and also medieval, of course, is much elaborated, much there, much historians have discussed about the medieval law, India, the law in the medieval India time, but ancient is still crying for some kind of recognition by the Indian scholars that is there in that particular. And it's not a tough, as I said, it's because of the doctrinal method of research you are not going to do there. Doctrinal method is normally a two-part process. अब तो तीन के क्या approach follow करना है, then process what is the there are two-part process. The first is the locating the sources of the law and interpreting and analyzing the text. Doctrinal method is normally a two-part process. Locating the sources of the law and then interpreting and analyzing the text. So doctrine is आसान लगता है, लेकिन यहाँ पर जो दो बातें हैं, interpreting and analyze. अगर आप देखो उसी को कितना इंटरप्रिटेशन हमारे सुप्रीम कोर्ट भी किए हैं 1950 में एक गोपालन के केस में 1967 में गोलकनाथ का हुआ उसमें क्या कि अनएमेंडेबल पार्ट 3 फिर उसके बेसिक स्ट्रक्चर डॉक्ट्रिन है तो ये सारा टेक्स्ट को काफी डीपली इंगेज होकर इंटरप्रेट किया गया एंड एनालाइज किया गया एंड देन दे ट्राई टू सी कि हाउ फार वी कैन स्ट्रेच व्हाट इज द इंटेंट ऑफ द ड्राफ्टर ऑफ द कॉन्स्टिट्यूशन सो फर्स्ट टाइम व्हेन द एक गोपालन केस we can't say it's wrong or right, but court looked at more in the how law has to be black and white. It's like simply as is what law has been stated. And court says the procedure established by law means what legislation has been done and there is nothing, we are not going to look beyond. But same procedure established by law when Menka Gandhi case has come, it looks into the, we can go back, we can try, we see whether we can test legislation, we can test the law whether it's a just, fair, reasonable. So legislature has no power to make any law which arbitrary, whimsical, and fanciful. If that is there, we can strike down. So court has interpreted, court has analyzed. So what court is doing, what we all have to do. So this is first point, which is the two process. The first is the interpreting and analyzing the text, and the second is the discussion and analysis of the law encapsulates and demonstrates the extent of research has taken place. One portion I'll take comparative and historical inquiries. So this idea I have discussed that the three points which I'll discuss. So comparative and historical inquiries in the doctrinal research. The first, describe an earlier era of contracting legal regime. जो हमारे होना चाहिए. It can be both in comparative and historical inquiries. What you are going to do, describe an earlier era of contracting legal regime. ये बात मैंने भी कहा था मैंने उसको पर. Second, contextualize. First, describe earlier era. Second, contextualize the selected era or regime. Contextualize the selected era or regime utilizing social sciences such as एंथ्रोपोलॉजी और हिस्ट्री। तो कॉन्टेक्स्ट में आपको लाना पड़ेगा जो हम लोगों ने डिस्कस है कॉन्टेक्स्ट वाला एंथ्रोपोलॉजी हिस्ट्री सोशियोलॉजी यू कैन आल्सो ऐड। Third, illuminate differences. Comma, choices or continuities. When compared with contemporary domestic practice. If we sum up, analysis, contextualization, comparative, and historical. These are the aspects if you look into that will be applicable to your doctrinal research in general and doctrinal research if you are doing on the ancient and historical aspect. There are plenty of scope which we have figured out. One can do that. When and how, that I leave it to you to decide, not to follow me, follow your instinct and work for the way. But of course, take note of your own career and perspective and accordingly. But one can develop. So after some time, one can. I personally feel ki more ancient perspective on the human rights I can look into, which is still missing. I have not developed. If I read more and more than ancient perspective of the human rights, we keep on reporting ICCPR, state obligations, judgments of the Supreme Court. But there is a scope on the historical way of interpreting human rights, where highlighting how Indian society was sensitive or insensitive, both way, towards the individual rights during the ancient and medieval time, particularly we can. Time.
Question?
Question at the beginning.
Yes, there.
Question, sir. First question is regarding the first session that we've had. My question is whether protection of Schedule 6 is necessary for protection of customary tribal legal systems. Whether Ladakh is then justified in asking for it. Because we've recently seen that Ladakh, after the bifurcation, the Leh Ladakh region is asking for a Schedule 6 protection, sir. So do you believe that Schedule 6 protection is the only way that tribal legal systems can have some sort of protection under the entire constitutional machinery, sir? That is the first question for the morning session, sir, if you would answer.
I think now Ladakh, so it means they seek their protection will be enhanced protection. That is the reason. So existing protection, so answer in both ways. The first is existing constitutional guarantees or other statutory guarantee, their protection is there. So it's not like, but they feel there are some more power will come if we go like district council, like regional council. There are a lot of powers there under the schedule, like for the Ghasi tribe, Karbi tribes. There are a number of the series of you'll find in 30-40 pages. So they believe that they will have some additional protection if we 7-6 schedule is applicable to them. But I don't know how this can be possible also. This can be applied, but it has to be go through the parliament.
Every tribal region would then ask for a Schedule 6.
But Ladakh has tribal population, no? So first criteria is the tribal population you are looking. So you want a tribal identity has to be protected. So first element they are fulfilled. They are not like people from the Himachal or like weak tribal population is there, they will have, but here they fulfill the 60-70% people have a like ST status. So earlier that was denied because it's a part of the Jammu and Kashmir. So they have, I believe, the genuine demand. and government should consider, because they feel the more autonomy will come. Right now, it's a UTA, so they govern through the 239 and other articles.
So one more question with regarding to the second session, sir. How do you differentiate between social science research and legal research? When we are talking about ancient medical aspect of legal areas, how do I then justify saying that it's a legal research and not social science research? As a research scholar of law,
I got it.
Yes.
So there's a difference. Legal research is purely legal analysis of the law, cases, theories that I have said, precedents that you do as a legal research. And then you test effectiveness, you see the development of law, then changes in the modification. So you do that. That is the complete exclusive legal research on the existing legal normative framework. And accordingly, you make a recommendation. Social science, if I go back to the Roscoe Pond and also the Eldridge, that like a living law. So they want law has to be tested in acts in the field. So social science, like what we are talking, and there is a culture also. Social, like ethnic, like how a ethnic community behaves, perception, how that particular thing. So a social scientist like Andre Bete, he has lived in a community for years together, and then he wrote a book. So that is his social science research. But a legal research could have been like, whether this community's social science research were some put of the legal in multidisciplinary, a legal researcher spend time with the community and say they are denied with their basic rights, that the right to life, the decent living, they don't have a food, so thus violated various right of the there. So, but that will merge. But it also figured in our discussion today that when you do the research, even if the multidisciplinary, not the social research, so interdisciplinary approach. What you say, interdisciplinary approach, where you have law and you have also focus on the economic law and economics, law and sociology or something. But still it has to be 60 to 70% reflection of the law. You can't do otherwise. If you leave and you do, then it complete social sciences. So you have to see चाय बनाते वक्त कितना चीनी देना है, कितना चाय पत्ती देना है, सिर्फ दूध से चाय नहीं बनेगा. तो मुझे लगता है कि सोशल साइंस यही थोड़ी सी ध्यान रखने की जरूरत है. और द डेंजर ऑल्सो आई हैव आइडेंटिफाइड, कहीं भी आप बोलोगे कि आपके टाइटल से लोग तुरंत बोलते हैं कि नहीं नहीं ये तो लॉ रिसर्च नहीं, जो ये डेंजर है. सो लॉ हैज टू बी रिफ्लेक्टेड क्लियरली इन योर टाइटल एंड अदर थिंग्स आल्सो.
Navadip,
My question pertains to the first session of the debate. If you refer to certain decisions, which I mean, if we look at the decisions of the Supreme Court, the legitimizing the penetration of state into tribal areas on the aspect of economic development, the owning of bauxite or any other mineral. So on one hand, this is the approach. On second hand, we want to preserve their indigenous justice dispensation systems. So, sir, don't you think that it's a kind of a paradox that if we penetrate in their area, and then we hope that we'll be able to secure and preserve the system that existed? So, how do you think that anywhere you see that balance, either created by Supreme Court or by the legislature, to preserve the identity of these tribal areas? But I think on economic aspects, they justify all sort of penetration.
Yeah, and unfortunately, court also takes the side of the state. That is even the Ministry of Environment and Forest also takes the side of the government. So some way, the problem lies in somewhere else. The development model which we follow, and that is the reason it's like hitting on number of aspects, not only tribal and other also, say poor farmers, weaker sections, women, children, everybody is even in environment in general. The development model which we follow is not based on the sustainable development model or right to development model or human rights model. What we follow economic model. Economic model which trust is how to take benefit, market oriented approach. When IPR also we talk about the protection of the IPR of the pharmaceutical companies, corporate. We are not talking about the poor students in the classroom, about the availability of books, access of books. or medicine for the poor people. So we focus about the more on the, we have compulsory licensing, but we have given only one compulsory licensing because there was a lot of opposition by the pharmaceutical company. We faced in locally and globally, vaccine patenting become a big issue. Now that has been settled at least for temporarily for the
So
5 years.
like when we look at patent aspect, the provision pertaining to compulsory acquisition under licensing, compulsory licensing procurement by the government. That sort of balancing provision we can see in the monopolistic law like patent. How do we fail to put that when it comes to protection and preservation of culture of tribals?
But I think, this is not only that key industrialized, but that will also graduate. The more outsider people will go there, their culture and other practices will be diluted one by one. And first, revolution will come from their family. The young generation who becomes education, they want employment. They are not particular about the culture. Then employment, the lifestyle, a lot of things will change, which happened in all the cities. Now the time has come. For various reasons, there are some kind of control, some kind of check is there. So the process is slow, but it continues. And court is also quite sure that they can't stop government. The court is aware of that fact. The government will overcome by the any means, by legislation or something. So some way, to conclude, we said unstoppable that globalization, and that because it works, so it will trample number of things, culture, practices, religion, number of things will be there.
I have a question. When we do historical research, we have a frame of reference through which we try to interpret. So generally, our values are reflected in interpretation. So it is a cross-cultural research. We are investigating a far past where we never lived. So how will we understand what kind of values those words signify in that particular culture? And from that very perspective, when Westerners try to develop research on Indian subjects, their own values are reflected in interpretations. But we Indians failed to develop our own history, in particularly in jurisprudence. There are very less books on the historical past regarding law, legal system, and development. So, what is the reason we failed to develop our own jurisprudence, and we try to imitate Westerners and their analysis of law and jurisprudence?
That is absolutely true. Any book, anything, we go to the Western philosophers. We talk about the Kant, we talk about the Rawls, we talk about the. Now we have more fashion to talk about the Michael Sandel. So we talk about the contemporary philosopher, and then look, we have maybe Gandhi can be considered a great philosopher, but nobody want to go to the Gandhi library to do the research. So these are the areas it's untouched, and if at all it has changed, so we have to do that. At least somebody has to start doing, and things will change, and the personal biasness will come for all. Whatever we say, if I write something, I'll Hinduism there. If a Islamic scholar writes Islam, so Islam will favor. He will look on that pattern. That's perfectly fine. But somebody will criticize. If Hinduism for somebody comes from the Western philosophy, you will become a critic. You can also critique, but our personal upbringing, culture, religious practices compels us to work on it, move on that direction which we have learned, not through the book, through the home, through the society, and through our surroundings.
Thank you so much, sir, for these two wonderful lectures and also explain research methods, problems in research methods, particularly in cross-cultural researches. So thank you so much, sir, for coming here.
Thank you very much, and all the best. Do well, and आप सबको अच्छी से आपकी सारे सपने पूरे हो, और जहाँ भी आप नौकरी करना चाहें, जहाँ कर रहे हैं वहाँ भी अच्छे करें, और भगवान करे आपकी सारी मुरादें पूरी हो. Thank you very much. Thank you.